Hello everybody, good morning. Welcome to this seminar on, well, I can't remember the title we gave, but something like negotiating the labyrinth of EU law on migration, asylum, something along those lines. But we're very happy to have two speakers today, who I'll introduce to you. They're both going to speak for around half an hour or so, and then we'll have time for questions. We have people join us online as well, who are very welcome, and they can obviously participate fully in the event, but to ask questions, please put them into the chat box. And if you have questions you want to put to the speakers, as I say, please put them into the chat box. My name's Andrew Geddes from the MPC at the EUI, and our two speakers today. First, we're going to hear from Dr. Fabian Lutz, who's a senior legal expert working in the European Commission's DG Migration Home Affairs. Currently, for this academic year, he's an EUI fellow, working on a project related to Schengen law. And our second speaker is Dr. Meltem Ineli-Siger, who is a Jean Monnet Fellow here at the European University Institute, working with us in the Migration Policy Centre, and also an Associate Professor of Law at the Süleyman Demirel University in Turkey. So very happy to welcome both the speakers. As I say, we will hear from them both, and then there'll be time for Q&A at the end. So, yeah, over to you, Fabian.
Thanks, Andrew, and good morning to everybody. My plan for today is, in these first 30 minutes, to guide you or to remind you a little bit of the basics of EU migration and asylum policy in general. And afterwards, then Meltem, she will deep dive into the specific component of temporary protection. What you see on the screen now, it's not modern art, but it is a mind map. And it's only one slide, so don't be afraid. I will just use this single slide for my presentation. And the aim is in 18 points, in 18 logical steps, to guide you a little bit through what we have at EU level currently, and also what we don't have at EU level currently, and what are the main challenges. So let me start straight away with point one. Why do we have an EU migration policy? That's not self-evident. So 60 years ago, when the EC was founded, none of the politicians had in mind to have a common EU migration or asylum policy. This only came up 30 or 40 years later with the realization of the single market, 1992, the single market objectives. There, the issue of internal border controls became more and more relevant. And then through the Schengen rules, which was originally coming from the intergovernmental field, because the UK didn't want to abandon border controls, so the other member states had to cooperate in an intergovernmental style in the 90s to agree on the Schengen rules. Through this idea and the realization of Schengen, which meant that it was realized in 95, that there are no more internal border controls, but a coherent set of external border rules, which meant that also migrants and asylum seekers could now, without being checked at internal borders, move from one member state to the other. And this led to a realization by member states, in such a situation, free movement within the EU, we also need common standards on migration and asylum. Member states, I always say, with the brain, they understood we need this common EU policy, but with the heart, that's until now, with the heart, member states still feel this is our national sovereign competence. Migration is really something like, political scientists, you call it high politics, like defense, sometimes culture as well, justice. They feel migration and asylum, it's so close to our national sovereignty, we want to keep it. And against that dilemma that on the one hand, member states see in a common Schengen space, we need common rules intellectually, and at the same time, they want to control migration. This is the main dilemma we are facing, we have been facing over the last 20 years now. And myself, I joined the DG Home Affairs in the year 2000. So together, more or less with the Tampere conclusions, also when the EU then finally got the hard competences to create common rules on migration and asylum. Over the last 20 years, I really experienced it in the context of a lot of legislative proposals. This big challenge that on the one hand, intellectually, there is a case for having common EU rules. On the same time, member states are strongly opposed to give up too much sovereignty in this field. And if you ask me now or later on, why is it so difficult to agree on Dublin rules? Why is it so difficult and painful to agree on the migration pact and all these proposals? Why is Brussels not delivering more consistently or quickly? The main explanation is exactly that. The difference between the emotional thing of not wanting to give up sovereignty, migration being so closely related to sovereignty, and intellectually the clear case of having these common rules. So since the year 2000, in essence, we have a fully fledged EU competence to legislate in the field of migration. Point two, free movement. Free movement, it's not what we have in mind when we speak about migration. Free movement that has been accepted, I think, quite from the outset by member states, that EU citizens, Romanians and others who move to Germany and Austria, they are beneficiaries of free movement. That's a different set of rules than migration, and this has been accepted by member states to the largest extent. There are still some problems. So free movement is a different set of rules and a different philosophy. When we speak about migration, we don't have free movement within the EU in mind. The tools, point three, the tools we are now using in the field of migration are the same as in other fields of union law. So we have gone away from this previous intergovernmental approach, the third pillar, where member states had the main right of initiative. Now we are really in the field of a genuine EU policy. So when new proposals are made, they have to be adopted by the Parliament in cooperation with the Council. So we are, so to say, in the normal field of union law. The only remainder of the old intergovernmental times is in the field of Schengen law. We have what we call the Schengen evaluation mechanism, which is a sort of a peer review mechanism, where member states together with the Commission go to other member states to assess whether the rules are properly applied. This sort of peer review mechanism does not exist in other fields of union law. Now let's cover a little bit and see what we have and what we don't have in the big fields of migration and asylum law. So classically we distinguish between the field of legal migration, asylum, irregular migration and international cooperation. In the field of legal migration, in a very simplified manner, we can say we have so far, Brussels has harmonized 50% of the rules, and the rest 50% is still remaining national competence. So we have the field of legal migration, 5 or 6 major directives which were adopted in the early 2000, 2002, 2003, 2004. They are dealing with specific categories of migrants who come for economic purposes. So we have, I think the most important one is the directive on family reunification, so that if a migrant is staying legally for some years in a member state and has not committed a criminal offense, he has a right, a real right, to bring the spouse and minor children in the territory. It's quite a generous act, which was adopted in 2003, which in that form probably today would not have been adopted, but it is in force and it's a very relevant directive. Then there are other sort of more sectoral directives dealing with third country students, third country researchers. On the low skilled end, we have a directive dealing with seasonal workers, and the high skilled end, we have a directive dealing with high skilled migrants, the blue card directive. And then we have quite an important one as well. It's the long-term residence directive. It's a directive. It's not so much known out in the public, but it's really relevant and important that anyone who has stayed for 5 years legally in an EU member state, for whatever purpose, it can also be a refugee, has a right to obtain this long-term residence status, which brings him or her very close already to the rights of a citizen. And on the basis of this status, the migrant then also has a certain right to also to move to other member states. This is also important in the asylum and Dublin debate, since, I mean, you know, there are some asylum seekers probably don't want to stay in Hungary, they want to go to Germany and Sweden. But if they are then forced to stay in Hungary and get in Hungary or in Romanian an asylum status, at the latest after 5 years, they can then obtain long-term residence status, and on the basis of that status, potentially move to Germany or Sweden. So this is really after 5 years, a migrant can obtain this consolidated status and move to other member states. This is quite an important element. Everything which is not regulated by the directives remains in national competence. This poses problems. It's the main field I'm speaking about is here this medium-skilled migration. The Commission proposed some acts, but they were rejected by Council. Member states really wanted to retain competence in this field. And this is also this wish of member states to maintain competence and also to determine the volumes of admission, you find specifically in Article 79.5 of the treaty, which enshrines in the primary law in the treaty that member states retain competence for determining the volumes of economic migration. So whatever we do in Brussels, member states can still impose quota for economic migration. If you ask me if this makes much sense, I would tell you no, it does not make sense, but it is a political reality. As again explained in the beginning, it's out of the wish of the member states not to give up too much sovereignty, but at the same time agreeing, yes, we need a common policy. So the outcome, you see, is somewhere in between. Turning now from legal migration to asylum. So in legal migration, the principle of our directives is in essence, if you fulfill certain requirements, you have the qualifications, you have no criminal record, you are needed for the economy and so on and so forth, you are admitted. In the field of asylum, the logic is a completely different one. In the field of asylum, the logic is that the right to be admitted is determined by your need for protection or international protection. And in the field of asylum law, and I think it's this is not only in the EU, but it's in each region of the world. Each region of the world or country which has asylum rules in force is faced with the same dilemma. It's not only now, but you can think back to the medievals if you think about the asylum in a church. To benefit from asylum, you must manage to be in. You must enter the church and close the door behind you, and then you are protected by asylum in the church. If you are outside the walls of the church, you are not protected. And to a certain extent, this is still the main dilemma of EU asylum policy, the same way in the Canadian, American, and in each state of the world, and also national asylum policies, is the way of, to benefit from asylum protection, you need to enter. The main dilemma indeed is access to protection. This is somehow characterizing and the whole debate we have now also in the latest years about connected to the migration pact, these new proposals which you made. What do we have currently in this field at a European level? We have this so-called the Common European Asylum System. We label it very proudly as Common European Asylum System, which consists in essence of 4 or 5 directives and a regulation. These 4 or 5 directives are directives dealing with the reception conditions for asylum seekers, so what you get in the beginning. They're dealing with the asylum procedures, the way 1 instance, 2 instance appeals and so on and so forth. The qualification of refugees and beneficiaries of subsidiary protection, a specific instrument related to temporary protection, we will focus later on, and a regulation, which is the Dublin regulation, the famous Dublin regulation, which determines which state is competent for dealing with a concrete asylum applicant. The Dublin regulation is the most contentious piece. We tried to modify it since a number of years, and so far we failed, at least since 2015 we failed. The history of Dublin, maybe briefly mentioning, it's the following, that when Schengen was negotiated, so Schengen was negotiated between 1985 and 1990, the geopolitical situation was quite different. At that time, the main entry route from asylum seekers were not through the land borders, but through the international airports. Because in the east of Europe, we had the remainder of the Iron Curtain, and so that there was no land transit through the eastern borders. In Northern Africa, we had relatively stable military dictatorships. So there was also no migration coming through the Mediterranean. So the main entry routes for asylum seekers at that time was through the international airports. And at that time, these Dublin rules, which foresee that the member state of first entry is in charge, were considered by most member states as sort of a fair technical solution for determining which member state should be in charge. So in 1990, in the Schengen Convention, and then also in the related Dublin Convention, these rules were fixed and then later on taken over into the Union acquis. However, the geopolitical, geographical situation changed, and as you probably know, now 2/3 of all asylum seekers enter through Greece or Italy. So if we apply the Dublin rules now, this rule of first entry, Greece and Italy would be in charge of 2/3 of the asylum seekers of the entire EU, which is of course entirely unfair. such a system. And for that reason, since the migration crisis in 2015 and also now with the migration pact, we have been proposing from the Commission side to change this system and to go for a more fair distribution based on counting the overall asylum applications in the whole EU and then distributing quota to member states. So let's assume just an example, if let's say 800,000 enter per year, then the quota for Austria would be 40,000 or 30,000. I'm just saying some numbers here. And if there are more than 30,000 coming, significantly more to Austria, then Austria would be able to ask for a transfer of asylum seekers to other states. This was our idea. It makes sense. Everybody agrees. It makes sense in a common European system without internal border to have such a repartition. But we failed to get agreement. Why did we fail to make agreement? We need, first of all, a qualified majority in council amongst the member states. And a number of member states, simply for principal reasons, notably this, what we call the Visegrad states, so Eastern states, Hungary, Poland, they were completely opposed to be obliged to take over asylum seekers from other member states for very fundamentalist, if you want, reasons. Then there were other member states who think that based on the current system, they may be better off than under the proposed system. Of course, they don't say it openly, but it led to them not agreeing to the proposal. So in the end, it was not possible for us, and we really tried each possible compromise to find a qualified majority in council for this reform of the Dublin system. We've made a new approach now with this proposed pact on migration. It's already now 2 years old, this new proposal. And it seems to me, I'll come to it later, that we are still facing the same problems here. That, I mean, it's very difficult to have a sort of member states agreeing on a solution which presupposes solidarity in taking over persons. Solidarity in terms of money, that's always easy when it comes to migration. But solidarity in taking over persons, particularly when it comes to persons which are ethnically or from a religious background different, poses a big problem to a number of member states. We can say it's bad, we can say it's deplorable, but it's a part of political reality. Asylum, access to protection, I spoke about it. What's the reply of the European Commission to this dilemma of access to protection? Also to all this, what we see now in the Mediterranean, these ongoing stories that, I mean, in reality, if you are an asylum seeker, if you come from Syria, if you want to enter the EU, the main route now is you have to pay a smuggler. You have to have $5,000. You go to a transit country, you pay the smuggler, and then you enter illegally. These journeys are extremely dangerous. And normally only those who have the money to do so and also who is healthy enough to sustain such a journey makes it to the EU. So it's also a very unfair system. It's somewhat the survival of the fittest, some Darwinistic access to asylum procedure. Of course, how could we solve this? The most radical solution, some may be in favor of, is simply to ask Frontex not to protect our borders, but to open a ferry service. The day from which we would open a ferry service from North Africa to Italy, there would be no more smugglers active and no one would drown in the Mediterranean. So why is this not done? I ask these questions frequently to groups of students or pupils, and they all look at me as if I was crazy. Yes, why it's not done? It's simply political realities that each government which would support such an open door policy would face significant political problems within several weeks or months. So it's politically not sustainable. There is in no member states a willingness to really have an open door policy and admit anyone who wishes to come. Against that background, our Commission approach is to focus very much on legal pathways to get protection in the EU and resettlement, because focusing on the most vulnerable ones, on those most deserving protection, and allowing those to enter regularly through resettlement programs, and that way also having somehow the moral justification maybe to be stricter in terms of protecting the external borders and preventing irregular entries from coming. Of course, we need to be honest, the EU is not Canada. Canada is in a very fortunate position because they have no real land borders and they can happily say, okay, we are very good, we have this resettlement program, but the EU is not Canada. We have these ongoing problems of, irregular migration through the land borders and high migratory pressure very close to us, which will not go away. So for us, it's not as easy as for Canada to be generous on resettlement, but still from Commission side, I mean, that's we think is the best way forward is this fostering strongly resettlement and legal pathways. Moving over now, points 8 and 9, what we see here, visa code, border code, these are the main hurdles a migrant or a third country national must face when he wants to enter the EU. These are the classical, what we call the key components of the Schengen rules, because they were agreed in these Schengen conventions, in the intergovernmental conventions from the 1985 and 1990. The Schengen Borders Code, it's a regulation directly applicable throughout the EU. It foresees two main principles: the absence of internal border control. You can travel freely through all Schengen states, including Switzerland, Norway, Iceland, and Liechtenstein, who are Schengen associated, and common standards at the external borders. This is the basics of the Schengen Border Code. And the visa code, on top of it, sets out certain lists of third countries which are visa-free and lists of third countries which are visa-obliged. And being visa-obliged means that even before departure, the migrant needs to go to a consulate and obtain a visa before being allowed even to board a plane and come to the EU. So these parts of the migration law, they work very well in practice and they're very well respected by member states. And we have these large-scale IT systems, the Schengen information system and others which complement the Borders Code and the Visa Code, so they work well in practice. You may have heard about this journalists and media complaining about the so-called Schengen crisis. What do they mean by the Schengen crisis? It's not a crisis of the Visa Code or the Borders Code. It's the fact that a lot of member states now, as a follow-up of the migration crisis, decided to reintroduce internal border controls. This reintroduction of the internal border controls, Austria vis-à-vis Slovenia, Germany vis-à-vis Austria, Denmark vis-à-vis Germany, is not per se illegal under the Schengen Borders Code. The Schengen Borders Code allows it in certain exceptional situations. The problem, and only for a limited duration of time. And the problem is now that member states continue to prolong and prolong and prolong for periods exceeding these periods. The legal trick which member states are using is that each time they say it's a different threat. Sometimes it's a threat caused by migratory flows, then it's a threat caused by smuggling, then a threat caused by terrorism. So, but then we had recently a case going to the European Court of Justice where the Court of Justice declared, I mean, you cannot somehow bypass the rules in such a way. These prolonged internal border controls are really infringing the law, and member states should change that practice. So this is from the Commission side. You will probably ask me afterwards, why, for God's sake, hasn't the Commission launched a lot of infringement procedures against member states? That's the question we are also asking ourselves. I'm working in the Schengen unit. We would also like to start infringement, but it's a political issue. And we have a political body above us, the Commission's president and the commissioners, with all this national, also political, I would say, they need to take into account the political reactions of member states. And if politicians have the choice of having a continued dialogue or starting infringement procedures, they always opt for the continued dialogue. So currently it's also that at the political level, the approach is rather, let's still speak to member states, convince them to abandon the internal border control and not go for this tough infringement procedure. Again, you may say this is wrong. Probably I would agree with it, or it's right. But I mean, it is, again, it's a reality we have to face in this constitutional structure we are living in the European Union currently. Point 10, irregular migration. Here the challenges which we are faced with are this, what we call these mixed flows. So on each boat which is arriving, there are genuine asylum seekers who will then probably, once in the EU, get refugee status, as well as economic migrants who come to the EU for other valid reasons, but for making a better life or sending money home to the families, but which will not be recognized as refugees or beneficiaries of protection in the EU. And the EU's response to these mixed flows is, in essence, to quickly distinguish genuine asylum seekers, channeling them to quick, fair and efficient procedures, and for irregular migration, then phasing in the possible return procedures. What are these clouds, 11 and 12? They should simply symbolize some of the horizontally, what happens to third country migrants staying legally 11, everybody staying legally, be it a recognized asylum seeker, be it someone who came under family reunification, be it a third country worker, they are then subject of the EU integration policy. And those who are not staying illegally, who have no legal status to stay, they are subject of the EU's return policy. The EU's integration policy is quite limited to giving money and fostering administrative cooperation. We cannot adopt hard legislation. So there is a clear provision in the treaty saying integration policy, it's not something for EU competence. The member states are free to determine what means integration. And what we can do is to give money and support projects which aim at integrating. Turning to 12, 13, 14, now return of those who have no right to stay. I mean, many people think that return policy itself, it's an infringement of human rights and it's a very unfriendly act. And I always say it is a necessary component of a migration policy. If you have a migration policy, you also have to have rules which you apply to those who don't fulfill the requirements, and you have to have means to enforce it. So even though, I mean, it's of course a hostile act to tell someone you must leave and then eventually in the worst case deport someone, but it's a necessary component of a migration policy. If we don't have that instrument, the whole migration system would lack its efficiency. So, and efficiency is again the keyword. Already here some of you will say rightly that nevertheless, even though we have these rather harsh return rules in force, there is a return directive from the year 2008, which sets out common standards for returning any illegally staying migrant. We have these rules in force. There is still only a 30% return rate of irregular migrants from the EU member states to third countries. So in a normal year, the EU member states issue around 500,000 of return decisions, and only around 50,000 can be carried out. Why is this? In essence, two reasons. Non-cooperation of the migrants. They pretend to be from another country or pretend to have a different name to avoid being returned. And non-cooperation of the third countries. So Western African countries, for instance, Sierra Leone, Senegal, they don't really have an interest also at the domestic political level to be seen as allies of the EU in repatriating their own compatriots from the EU to Senegal. So these two problems, I mean, non-cooperation by third countries and non-cooperation by the migrants themselves lead to the situation that we have a very inefficient return policy. And when you listen to the European Council conclusions and what member states say, frequently member states disagree about a lot of things, notably on asylum and legal migration. But where all member states agree is always, we need a more efficient return policy. So this is really the key slogan, the key word you find in all the European Council conclusions. What are the tools for doing this? The tools, it's point 14 and another 15. Cooperation with third countries and readmission. And here in terms of readmission are international agreements under which the EU agree with countries like Pakistan or Sri Lanka or others to take back their own citizens and possibly also others who transited through the country under simplified procedures, under a simplified also evidence procedure. So sometimes it should be enough if the person simply traveled through the country, through Albania, then Italy can send back the person to Albania. These readmission agreements are in practice very important, but third countries don't have sometimes very much interest of concluding them, so they need to be offered incentives. And that's the whole debate we have now with the incentivization. There is a debate about positive incentives, so the EU can offer a visa facilitation, quota for legal migration, trade facilitation and other issues in exchange for getting readmission agreements. And there is this sort of negative incentives, which was introduced also through a recent change of the visa code. We say we take away visa facilitation from India if India does not properly cooperate on readmission. So there are some facilitations, frequent traveler programs or business visitors visa where EU member states have a leeway of taking away disadvantages for legitimate travelers. Again, you can say it's good or it's bad. I simply described that this is currently happening. I mean, it's on the political agenda. It remains a very important point, this cooperation with third countries in order to obtain cooperation on readmission. And next to that, also point 15, very high on the agenda since 2015 is also cooperation with third countries in order to tackle migratory flows. So what, I think in other workshops, it's frequently labeled as externalization of border policy. So to cooperate with Northern African countries and Turkey to make sure that migrants don't even arrive at the EU. What's the driving power behind that? The driving power is, as I said, as soon as a migrant reaches EU territory or boards a ship which is controlled by the EU, the migrant has a right to be brought to EU territory and have a application for asylum be heard, even if it's a fake asylum application and that the migrant gets then in the end a rejection and a return decision. In many cases, in 70% of the cases, return will not work for the reasons described above. So, I mean, there is a huge incentive also as for a normal irregular migrant simply to try his luck and come. And so, and then EU member states will have problems in actually returning this person. So, a more efficient tool would be then, again, you can say it's completely immoral or bad, but I just describe realities. So an efficient tool is that you work with Turkey, you work with Morocco, you work with Tunis, and agree with them that you help them to train their border officials, the national border officials, so that they prevent actually the departures. So this is also an issue which is increasing on the political forefront in order to tackle these migratory flows to the EU. Of course, then also in the context, it's not only the repressive side, but also then a more positive side, such as helping in countries of origins, helping neighboring states to house refugees. So the EU is still paying the Turkey for financial amounts for housing 3 million of Syrian refugees. So or also tackle root causes of migration. I mean, of course, this also goes then in trade policy, development policy, fisheries. All this is interconnected. So this is. Let's say, since 2015, awareness within member states and also the European Council has been increasing that migration has a big political dimension. And so it gains much more attention, this tackling the root causes and cooperating with third countries in order to tackle migratory flows. I'm coming already to the end, point 16, 17, 18. 16, the IT systems, we have some very big and well-operating IT systems, notably the Schengen Information System, which is a big system, and you all were controlled in the SIS, probably without being noticing it. Whenever you cross an external border, your passport ID is put against the scanner, and within 3 seconds, the border guard sees whether there is an arrest warrant against you, whether this is a stolen document, and it works throughout the EU. So this is really an extremely helpful and efficient tool for tackling crime, document fraud, for finding missing persons, abducted children, and all that. Then we have visa information system. Then these two systems, entry-exit system, EES and ETIAS, it's sort of a pre-travel clearance for visa-free travelers. They are already adopted and will enter into operation probably in 1 year's time. So this will be a big new sort of a step towards, some critics say, making Fortress Europe stronger. Others say will facilitate travel for the bona fide travelers and make our asylum border regime future-proof. And then we have the database of Eurodac. Eurodac is a database where fingerprints of irregular migrants as asylum seekers are taken for the implementation of Dublin. So agencies, briefly again, we have now feel 3 big agencies, Frontex in Warsaw, the European Asylum Support Office in Malta, and EU LISA for the informatic systems in Tallinn. They are supportive agencies. They're not federal agencies. Frontex cannot, out of its own will, go to the Hungarian border, to the Greek border, and say, we as Frontex control. Frontex can only act if it's asked by Greece or Italy to help and assist. And only then Frontex can phase in. And when Frontex is acting there, it's not implementing EU law, but national Italian law or national Greek law. So the Frontex ship operating in Greek waters, refusing entry or pushing back, depending on how you describe it, migrant, is acting, in fact, in application of Greek law, and legal remedies would have to go to Greek courts. This is the current constellation. So we are not yet at a stage where there is really a truly federal EU agency in charge of migration. And last but not least, money. We have big sort of financial instruments, top financial pots, where on the basis of solidarity, the money is paid into this pot by everybody, and the more your burden is, so that the longer your external borders are, or the more migrants you have to integrate, the more money you get out of it. This already leads me to the conclusion. Where do we stand now? What will happen? You know that in 2 years ago, the Commission proposed this pact on migration. This pact on migration, in essence, is not a pact, because for a pact it needs two sides to agree. It's a set of proposals for reforming Dublin, for reforming the return policy, for again reforming some of these provisions. These proposals are all under negotiations, and it seems that negotiations, to say the least, are very difficult. I was personally in charge of one part of the pact, the screening regulation, where we finally managed to reach agreement in Council, which was as such as difficult, but now the challenge is to get agreement with the European Parliament. And European Parliament and Council really in the last 5 years drifted dramatically away from each other. So it's very difficult now to see a scenario under which Council would agree with the European Parliament in this field of asylum and border-related measures, because the orientation of the Parliament is very, very much towards protection and enhancing fundamental rights, and the direction of Council is rather of control-oriented, if you want to put it that way. Again, you can say it's bad or good. I'm simply describing realities. So if you ask me what will be the likely future development in the next 5 or 10 years, I mean, I hope, of course, and I also have to say this because I represent the Commission, I hope that these pact proposals will be adopted. But as a sort of we have to hope for the best and prepare for the worst. What would be the worst, or what would be the alternative scenario be, is simply that we continue to live with the existing rules, as interpreted by the European Court of Justice, because the European Court of Justice is playing an increasing role in interpreting our rules. So the court becomes a sort of surrogate lawmaker. And next to it, we will continue with the EU member states cooperating with transit countries in order to tackle migratory flows. That's all. I hand over.
Thank you.
So straight away we'll hand over to Meltem and we'll get questions at the end.
Okay, thank you very much. Thank you, Andrew, and the MPC for the invitation. Also, thank you, Fabian, for summarizing the whole EU asylum and migration acquis in less than half an hour. That's, I think, a big achievement. But also openly presenting the rationale of the Commission for why they act when they do. So now I will take over and perhaps mention and talk about a quite specific area of EU asylum acquis, and that is temporary protection. But before I move on to my presentation, perhaps I should explain why a Turkish academic is giving a lecture on the EU temporary protection laws and policies, and perhaps also presenting some of the new research on that. So 7 years ago, I finished my PhD at the University of Bristol Law School on temporary protection. So in my thesis, there was no EU TPD activation, and I compared temporary protection laws and policies around the world. So I am Turkish. We use temporary protection to protect more than 3.5 million Syrians in Turkey. The US has a national temporary protection status called US TPS, temporary protected status, which they do not open borders and let people in, but they protect persons who are inside the US who cannot return due to environmental disasters, civil wars, and other kind of reasons that you cannot really, bless you, you cannot really return to. So there are also temporary protection visas in Australia where they undermine the Refugee Convention. So this is not a very good practice. In Australia, we have really bad practices of temporary protection and other asylum laws and policies. But I have worked quite a bit on the temporary protection of Bosnians and Kosovars in 1990s. So at that time, the EU didn't have, as also Fabian mentioned, didn't really have a common asylum policy. It started, the Temporary Protection Directive started at the Tampere conclusions. But what happened is that for those displaced by the conflicts associated by the former Yugoslavia's the solution, member states such as Germany, Austria, the Netherlands, Sweden, many member states implemented their own national temporary protection laws and policies, but there were many differences between them. So one, for instance, Germany was giving Duldung status and another status which is generally granted to war refugees, but at the same time the right to work was an issue. There were also differences about which rights are given, which services was given. So there were secondary movements, people were moving who have fled Bosnia and Kosovo, they were moving around. In the context of Kosovo, there were humanitarian evacuation programs where member states were willingly actually getting and sending planes to Macedonia at the time and taking people back. So there were many differences between how member states acted and responded to mass influxations and how they actually give rights and entitlements to the temporarily protected persons. So in Tampere, the EU decided to come up with a piece of legislation that would actually somehow harmonize the entitlements and rights of temporary protection beneficiaries, but also to share the burden. I say burden not in a negative way that refugees are burdened, because mass influxations create problems for the member states. They may lack infrastructure, they may lack economic or financial capacity, they may lack extra places for children. So older refugees and temporary protection beneficiaries cannot be defined, of course, as burden. They are quite valuable beings, but at the same time, what we call mass influx or large-scale influxations bring enormous challenges for the host states. And this is the same for Turkey, this is the same for Latin American countries, this is the same for Europe. So therefore, the EU wanted to become prepared for the next mass influxation, which is, I think, in the case of Bosnia and Kosovo, this was where the EU borders lied. And in the case of Ukraine, we also see that this piece of legislation, the Temporary Protection Directive, was activated when there was a war and root cause in the nearing borders of the EU. So after this introduction today, let me give you my outline. So first, I will take a look at temporary protection laws and policies in the European Union and provide an overview for those of you who may not necessarily know much about temporary protection. And secondly, today's I thought quite interesting is to talk about non-Ukrainian asylum seekers and refugees who were forced by the full-scale Russian invasion in Ukraine after February and how they are protected. And I gave the title Labyrinth because as you will see, the legal rules that apply to them are quite complex, even for those who are working on EU asylum area. So finally, I have co-authored a report which is done in collaboration with the highest and Right to Protection, which is a Ukrainian NGO working with refugees and asylum seekers there, and I will present some of its main findings, which I hope that you will find interesting. Okay, starting with the Temporary Protection Directive. As I mentioned, Temporary Protection Directive's full name is quite long. We call it TPD, or the Temporary Protection Directive, but this piece of legislation was actually one of the first which have been adopted within the scope of EU asylum laws. This was the second directive after Eurodac regulation adopted in the context of common asylum rules. And this so far has not been activated. So when I was actually mentioning my thesis, it was quite theoretical. So when I was working on Temporary Protection Directive, I was trying to come up with reasons why it has not been activated. So far I was lucky. I think I was working in a study commissioned by the European Commission in 2016. And here with other researchers, we were trying to find out how this obsolete piece of instrument can be implemented and activated again. So we came up with quite complex reasons at the time, but I will mention in a second, they all actually were not valid reasons, because at the end, the activation of this piece of legislation depended on the political will of the EU. So it was activated and it remained obsolete for the 2 decades. So because the Commission and the Council never wanted to be activated in other instances. So here I mentioned activation or a mechanism, and let me briefly explain this. Normally, EU asylum directives apply when it enters in force. But in the case of Temporary Protection Directive, because it is designed for emergency instances when there is a mass influx, it has this activation/trigger mechanism. So when a member state or more than a few member states have a migratory pressure and feels that they cannot cope with the situation with their national asylum and reception systems, they may ask the Commission to prepare a proposal determining that there is a mass influx and Temporary Protection Directive to be activated. But member states cannot propose activation from the Council directly. The Commission, until 2022, has never actually proposed officially activating the directive. This didn't happen when there was the so-called migration crisis in 2015, when more than 1 million persons have arrived via sea from Turkey and from Northern Africa to Italy and Greece. This didn't happen after the Arab Spring conflicts, when Italy was really tested because the number of persons arriving and this was mixed flows, as Fabian mentioned. So there were actually many refugees in these situations too. Imagine those who had fled Syria, where they really cannot return because there's an ongoing civil war. So I have always argued that this Temporary Protection Directive could have been activated in these instances, but the Commission never really officially proposed this activation, although there were calls from Libe Committee, some of the MPs. It never happened. And as a result, the Council never activated the directive. And here in the context of Ukraine, we saw that this piece of legislation becomes such an instrumental piece for managing the forced displacement from Ukraine due to full-scale invasion. Here, there's a timeline, and you will see that after, unfortunately, the full-scale invasion began, what we call is that the Commission repeatedly proposed the activation of the directive, and we see after only 2 days of the proposal, the Council unanimously accepted activation, which was the right response, and this was a very good development for the protection of those who are forced to flee Ukraine. But the Temporary Protection Directive is a piece of legislation that was adopted in 2001, when EU asylum policy was just beginning. So it does not have common standards, but it only has minimum standards. So it only mentions what member states should do in a minimum way. And this leaves pretty much a lot of discretion to the member states on how to fill some of the gaps in this directive, but also how to act. And there are Commission reports, UNHCR reports, and EUAA reports now telling that there are differences in how temporary protection laws and policies actually work in different member states. And I will mention that in a second. But also, this legislation has a number of weaknesses because it never talks about procedures. It doesn't really outline how eligibility for temporary protection should be contacted. In some member states, this is quite straightforward. You just show your Ukrainian ID, for instance, and they give you in a few hours your temporary protection card and resident permit attached to that. But in some member states, you get an online appointment. It takes a few months. In Spain, for instance. And there are quite differences about registration procedures. About exclusion, there are problems as well, because then you have some people engaged in conflict in Ukraine and then they flee to the EU, and how do you deal with that? Whether exclusion procedures will work or not, and how do you make that assessment? So there are some gaps in the directive because it has never been recast, updated in the last 20 years. So member states are trying to fill this gap to the best of their ability and to the best of their political response, how it foresees that. So there are many divergences between how temporary protection laws work in practice. And here we see a very rapid activation of the directive, and Commissioner Johansson mentioning this is a very good thing. Although in other instances, the Commission, I do not remember no one from the Commission to identifying temporary protection directive as a crucial instrument for responding this kind of conflict situation and displacement. Okay, so who can be granted temporary protection? We have Council's implementing decision issued in March, and when we read this implementing decision together with the Temporary Protection Directive provisions, we have an answer on who will be granted temporary protection under EU laws and policies. And this is Ukrainian nationals residing in Ukraine prior to the beginning of the full-scale Russian invasion and their family members, but stateless persons and third-country nationals who benefited from international protection or national protection status. And because I've been working with a lot of Ukrainian colleagues in the last few months, so far they only have complementary protection. And there's no other subsidy protection or temporary protection. They only have complementary protection as a national protection status. So for those who are benefiting from these two statuses and who are have been displaced due to Russian invasion on or after 24th of February, as well as their family members. But the Council decision said you should either give temporary protection or any adequate protection status to those who were holding valid resident permits, but this permanent resident permits, and who cannot return to their, or expected to return to their country of origin. So this is the Council's implementing decision. But member states are free and have the discretion to extend temporary protection to other groups, and we will see in a second who they have done that. Okay, so what temporary protection offers? Temporary protection offers a certain category of rights. Compared to what asylum seekers get, this is better rights and more entitlements, but compared to those enjoying subsidiary protection or refugee status in the EU, this is less rights. So temporary protection lies somehow in between about those who are eligible for asylum seekers and those rights that are granted to international protection status holders. But for me, this is quite a decent category of rights, but bear in mind, these are designed to satisfy the basic needs of those fleeing in a mass influx situation. So you see here, right, the social assistance, which should include access to subsistence costs, so food, social assistance if a person needs a suitable accommodation and shelter, employment, which is a very good thing because then temporary protection beneficiaries can have access to labor markets right away. But also the Commission and the Council decided not to implement Article 11 of the directive, which foresaw some kind of Dublin mechanism for temporary protection beneficiaries. So this is a very good thing, because as academics, we have been criticizing Dublin rules for, I think, as long as I'm in this field, and many professors and many academics has been going on and on about and identifying problems with the Dublin. But this time the Council said, you know what, we do not need Dublin. People can choose where they want to apply for temporary protection, stay there, and even if they register in one place, if they want to move to another member state for a limited of time, they're free to do so. This is a great thing. Why? Because it gives agency to those protected persons, so they can actually choose where their relatives live, or where they want to work, or where they know the language, or have education. So this is a great thing. It doesn't apply to asylum seekers, but it is a very good thing, and we hope this can be modeled after, perhaps in the future, for asylum seekers and refugees, because at the same time, this enhances burden sharing and responsibility sharing between member states, because when people choose, they go different places and different states, and this is a normal and natural way of burden sharing. Okay, so when temporary protection will come to an end? Temporary protection can only go up to 3 years. So after 2 years, it should be terminated. And the Council and the member states will decide then what will happen to those enjoying temporary protection status. I think, and I'm being asked in many seminars, what is the best way perhaps? And I think, so the EU cannot regulate citizenship laws, right? Because member states retain the prerogative to actually regulate citizenship laws. But as EU, what they can do is, for instance, if the conflict does not end in 3 years, and I hope it ends soon, but at the same time, it doesn't end. I think for me, the most pragmatic way to give temporary protection beneficiaries the long-term resident status so that they can enjoy certain rights in the best way possible. But of course, some member states want to give citizenship. This is perhaps a better option. But at the same time, hopefully, if the Russian invasion ends soon, then and it becomes safe for temporary protection beneficiaries to return, the Council can terminate it at any time. Okay, so this is temporary protection laws and policies in a nutshell. Now, let me get to the specific population of asylum seekers and refugees in Ukraine who had to flee due to a full Russian invasion to the European Union countries. So what happens to them? Okay, so let me talk about this population, because compared to, of course, the number of Ukrainian nationals who have been displaced, this is a very minor population, because the numbers, although it is not clear, the UNHCR estimated that there were around 5,000 refugees in Ukraine at the end of 2021. But these are the official numbers, and they not include asylum seekers. At the same time, according to UNHCR, there are 26,000 stateless persons registered as stateless persons in Ukraine. So we do not know how many exactly sought refuge in the EU or stayed in the Ukraine. But when I was presenting to the Libe committee, the Commission representative mentioned that there were more than 2,000 third country nationals and stateless persons who have sought refuge in the EU, but this includes students as well, which is so we do not know the exact number, but this is less than 5,000. So where these people came from, these people were coming from Syria, Afghanistan, Russia, Somalia, and other former Soviet republics such as Tajikistan and some other places. So after the full-scale invasion began, from the written submissions of the Ukrainian NGOs working with refugees, we understand that because it's military law now, the SMS, which is the Ukrainian Migration Authority, does not issue new asylum-seeking documents, which is called MSID, or does not process new protection status claims. So this is the information we got from asylum seekers. Okay, so who's eligible for temporary protection among third country nationals and stateless persons fleeing Ukraine? So this is my conclusion and lesson drawing perhaps from the Council's implementing decision. So non-Ukrainian refugees and complementary protection status holders who have fled Ukraine on or after 24th of February should be eligible for temporary protection. Or those who have family members. For instance, if you're a spouse of a Ukrainian national, or if you're a child, if your child is a Ukrainian national, you are eligible for temporary protection in the EU. As I mentioned, those who were holding permanent resident permits and who cannot return in safe and durable conditions to the country of origin may be granted temporary protection or any other national status. And finally, if the member state you're applying for temporary protection has a liberal interpretation of temporary protection and extended scope to you, then you are eligible for temporary protection. That's why and here is an analysis drawn from different documents, including the Commission documents, acquis information sheets, and also fundamental rights FRA. So we see Spain is perhaps the member state that has extended the scope of temporary protection the most, because it grants temporary protection, among others, to third country nationals and stateless persons who were legally residing in Ukraine even before 24th of February. We have Portugal, Germany, Finland, Croatia, and Czech Republic, Belgium, and Spain that has extended scope of temporary protection to some groups of stateless persons and third country nationals. I will give you a minute to take a look of the scope if you're interested. The reason I call this legal labyrinth is that even I have been working on temporary protection for so long and EU asylum acquis for many years, This is as a result of a very comprehensive research. So I look at different sources, I analyze different member state laws and policies in addition to EU, and these are the conclusions of mine. Imagine that you are a person fleeing Ukraine, you're just an asylum seeker or a refugee, you have no knowledge of prior knowledge of EU asylum acquis, you do not know where to get legal assistance, because although EIA and member states have many very useful information sheets and also web designs and call centers for Ukrainian nationals fleeing Ukraine, they do not have the same service for those fleeing as refugees and asylum seekers. So as a result, I will mention in a second that this kind of very little but vulnerable group lacks legal assistance and legal information. So I think, I'm sorry. Yes, okay, so we see non-Ukrainian asylum seekers are not in principle eligible for temporary protection unless they have family members that can benefit from temporary protection. They are not holding any kind of permanent resident permits, and what have been told by us to the Ukrainian colleagues is that very few people actually held permanent resident permits in Ukraine before the conflict began. So there is not much people who are eligible for this. And also, if you're not applying temporary protection in a state that extends temporary protection to you. So if you're not eligible for temporary protection and you're an asylum seeker or a refugee fleeing Ukraine, how can you be protected in the EU? Then you need to apply for asylum. And when you apply for asylum, as Fabian marvelously summarized, then three main directives apply to you. So your status is determined on the basis of recast qualification directive. You are registered as an asylum seeker under the procedural laws of the APD, the Asylum Procedures Directive, and your reception and your accommodation is regulated by the recast Asylum Conditions Directive. And here. Okay, so why holding a temporary protection status is better than being an asylum seeker in the EU? Of course, this is a very quite generalization, but at the same time, we know that asylum procedures and refugee status determination goes on sometimes in member states up to 1 year and more. So you need to wait a long time for your status to be determined. So unless you are eligible for refugee or subsidiary protection status, you're an asylum seeker. And when you're an asylum seeker, you get access to some rights, fundamental rights, but not as much as those temporary protection beneficiaries. So my argument is that if you are holding a temporary protection status, you are in a more favorable place. Of course, if the member state you are applying decides on your application in a few days and you're granted refugee status, then temporary protection beneficiaries get less. But it depends on the member state and how their asylum system works. So you have, as I mentioned, in theory, access to more rights and better protection standards when you're a temporary protection status holder. Okay, the final part of my presentation is, as I mentioned, this highest right to protection report that I have co-authored on this population, non-Ukrainian asylum seekers and refugees. So this report is about 4 categories of persons: non-Ukrainian asylum seekers with or without MSID documents, and this is kind of a documented that you are applied for asylum in Ukraine, but this is not an identity or travel document. So this shows that you have applied to the migration authorities, but they may expire. So if you do not renew this document, you have an invalid one. So that's why the study includes both those holding MSID documents and those holding expired or not valid MSID documents. As I mentioned, in Ukraine, there is complementary protection status, so the report also includes these groups, but also non-Ukrainian refugees, so those who are recognized as refugees in Ukraine. Here we have the methodology. Methodology is based on desk research, but also analysis of EU and member state laws and policies, but also surveys is conducted by the Right to Protection, which is the Ukrainian NGO we have been working with. They conducted 300 interviews in total relating to those who have fled to the EU plus countries, which was quite difficult because they needed to trace individuals and then keep in contact with them. So we also have received written submissions from Ukrainian NGOs. The report is about protection of non-Ukrainian refugees and asylum seekers who have fled Ukraine, but also they document access to rights in Ukraine and the European Union. It will be published in January. Okay, so the main findings of the report. So the surveys under desk research and written submissions showed that nearly half of the respondents didn't hold temporary protection status in Ukraine. This is partly because the Council's implementing decision scope is limited, but at the same time, we have received a lot of written submissions from the respondents, and also interviews showed that there were many problems with their access to temporary protection procedures. There were respondents mentioning that while Ukrainian nationals got temporary protection status in a few days, we had to wait up to 5 months, because they were respondents saying that although holding a complementary protection status, which makes you eligible for temporary protection in the EU, they were rejected because they are told you are not Ukrainian, you are not eligible for this status. So the UNHCR report also confirms this as well, because they identified and found that non-Ukrainian third country nationals and stateless persons are mistakenly referred to asylum procedures, despite the fact that they were eligible for temporary protection in the EU. Moreover, we had non-recognition of documents submitted by the individuals, and so some member states didn't recognize migration documents issued by the Ukrainian government, either because they couldn't understand the language or read the language, or because they didn't know such documents exist and they didn't recognize them in protection procedures. And another valid finding that we got is that people had a lot of problems with access to identity and travel documents. In Ukraine, we are told that you need to surrender your passport to the migration agencies if you're an asylum seeker. And in the first weeks after the full-scale invasion, the EU borders were open and people fled without even having travel documents. So they didn't need it. But now they need it, because we are told that the Ukraine-Poland border is much strict now. So you need to show your travel documents. So those who have fled to the EU in the first weeks, they have family members in Ukraine, they have relatives in Ukraine, they want to return back, see them, and then perhaps move on to EU again. But they cannot do that because they do not hold valid documents, travel documents, and in practice, they're not allowed to re-enter Ukraine and leave the Ukraine again without valid travel documents. So this was identified another problem. And those who doesn't hold valid travel or ID documents, they cannot open bank accounts, they cannot receive social assistance from local authorities. So this creates a lot of hurdles in terms of accessing rights and services. Finally, we have found out that 20% of the respondents remain undocumented, in addition to their children. So this is a significant amount, because although the link we have realized it with the questions that we asked, there was lack of adequate information and legal assistance to them. They didn't know that they are eligible for some sort of protection status. They were afraid of the authorities because they thought they might be deported. So a significant amount of persons remain undocumented in the member states. So 2 minutes. Okay, my last slide. Great. So finally, there were also many challenges for those who were exercising the right to freedom of movement. As I mentioned, temporary protection beneficiaries can enjoy a certain right to freedom of movement, but nearly 80% of asylum seekers and refugees who have fled Ukraine, despite the fact that they have a freedom of movement, they said they do not know that such right existed, or they cannot really travel because they lack documents. So this is a right in theory for them, so majority of them. And this was one of the, I think, highlights of the main findings of the study. Moreover, there were problems with access to affordable housing, food, healthcare, and livelihoods. Now, This is also the same for Ukrainian nationals, because there are many reports by the UNHCR, Save the Children, other NGOs, acquis, and for Ukrainian nationals as well, accessing affordable housing in the member states became such an issue. And this is the same for non-Ukrainian nationals who had to flee, because this is also in relation to the housing crisis in the member states, in Europe in general, the inflation in food prices. So accessing to dignified standards and livelihoods is becoming really challenging for them. And finally, all those findings show us that the EU does not have the systematic comprehensive policy designed for the non-Ukrainian third country nationals and stateless persons who are forced to flee Ukraine due to the conflict. So these are vulnerable people that cannot return back to their countries of origin. They cannot obtain travel documents or IDs from their countries of origin, but because of the Ukrainians in military conditions, they cannot obtain them from the Ukrainian authorities as well. So they're in limbo, and the EU, as well as other stakeholders, do not have a consistent policy for their effective protection. And I conclude here. Thank you very much for listening.
Thanks, Meltem. So we've had two very rich presentations. We've got time for questions now. We can take questions in the room, and we can also invite questions from people who are joining us online. So who'd like to start? So I see Federica, then Martin. So just let me know and I'll put you on the list if you want to ask questions, and obviously anybody online too. So Federica.
Thank you so much for both of you. I have a question for families. It connects to what you said in the beginning, the tension between
Thanks, Martin.
Yeah, thank you for these two really wide-ranging presentations. I have one question for Melton, which is just a factual question. So what rights protections are available to all those Ukrainians who were already in the EU before February 2020 and in irregular status? Because obviously there's been a lot of Ukrainians who have joined their friends and relatives. I'm just wondering about the discrepancies in rights. And Fabian, I'm just wondering, obviously, I mean, you've got huge experience and kind of long history working for the Commission. I'm just wondering if you could reflect on two arguments that I would make. One is this issue of, well, there seems to be now, there's a huge discrepancy between the very high quality standards we now have within the European Union and the kind of rights that EU citizens have, and the very kind of quite harsh policies the EU applies to non-EU citizens. I think it's, in some sense, it's reasonable to argue that we give preference to EU citizens, but now the gap is so large. It seems to me the argument is being made that in order to maintain Schengen and free movement, we need to have these harsh policies. It's highly problematic, I think, from a kind of moral perspective, but also from a political perspective, this idea that we need to become, you know, if there's this trade-off, then the freedoms that Europeans have must always have absolute priority. So I'm just wondering to what extent that kind of reflection is part of Commission thinking. And the other point is a comment on the head versus heart. I mean, I know it's a simplification, but I mean, I would again question both sides. I mean, the head, I think one can make arguments, one can reason why it might not be a good idea to kind of integrate and harmonize all migration policies. And again, that's not what you were saying, but I'm just saying that I think one can make arguments why it might not be a good thing, just from the heads, using the head, that, you know, given different welfare states, different labor markets, different national institutional contexts, why a full harmonization of migration policies might not be a good thing. But also in terms of the heart, I think the heart is sometimes, I mean, the heart can be foolish, right? I mean, if that's the connotation that people have, but isn't the heart, of course it's about politics, but then it's also about, again, these national contexts. It's about, people might think differently about how welfare is being organized or about how, you know, these things should be tackled. So again, to what extent is this diversity in EU member states, in norms and institutions, recognized as a potential reason for why we should not kind of think that the more we integrate and the more common policies we have, the better? Thank you.
Okay, so should we start with you, Fabian, and then hear from Melton?
Well, thanks for this question. I'm turning a blind eye to the, what you say, in fact, not correct application of certain EU rules by EU institutions. I mean, what I mean, why isn't the Commission starting infringements when Greece is apparently doing pushbacks, which is an infringement, or why isn't the Commission launching infringements when Germany is for the 10th time prolonging an internal border control when it's not supposed to do? Or also why is the Council blindly, not blindly, but silently accepting such policies? I mean, I think I already gave a sort of discrete answer. It's a policy context. But legally speaking, if we were just a legal machine and we see certain rules are not applied, there should be an automaticity, infringement procedures to be launched, and then the European Court of Justice would deliver a judgment and member state would have to correct. But this, we are living in a political reality, and the Commission is also a political body. But notably in respect of what's happening at the external border, there is this sort of a perceived dilemma of, on the one hand, full respect for fundamental rights, on the other hand, a strong political willingness to limit migratory flows, which is maybe sometimes very difficult to bridge. And if you're looking for the explanations is directly there. This is an underlying policy consideration. So I can assure you that we at the technical level in the UN, we are fully aware of all these constraints and we're discussing with colleagues. But then also to launch infringements or to do something against the concrete member state requires a political decision. And the political considerations, they somehow escape then the purely legal logic. On your question, Martin, on high standards EU, low standards for third country nationals, I'm not sure that I understood it correctly. So in my view, we have very high standards within the EU for EU citizens, but we also have high standards for the legally staying third country nationals. So if you're legally staying as a third country nationals, you can obtain long-term resident status, and then your single permit directive, you're not discriminated against, have equal access. So for those who are legally staying, we have also, I would say, relatively high standards. The problem may be about the undocumented third country nationals here, or the non-removable returnees, what's happening to them, because they are somehow in a limbo also within the EU, and also third country nationals who are outside the EU. And there, it's of course again this question of access to the EU, access to the protection, the dilemma, having an open door or not. And then I can only, based on my experience also, what I see it's happening in member states, say that the willingness to take in migrants in general is there, but it is limited. So it's a political reality we have to face, and you can argue again, it shouldn't be like that, or it is like that, but there is some of the whole migration law. I mean, I sometimes nickname, if I want to be provocative, I nickname migration law is somehow a form of legitimate discrimination, because with migration law you set out which rules are different vis-a-vis their own nationals, the way how we are balancing these rules, and well, that's all what migration law is about, finding the balance on this, and that we have to face in political realities. And the last point, head versus heart Schengen, and I think that the main point really, and also that's my argument, is that Schengen in itself, the absence of internal border control, is of enormous importance also economically, so that you can simply travel through from Germany through Austria to Italy without having to wait. It's extremely economically important. In principle, it was always designed to be only there for EU citizens. Then you have the problem of third country nationals. They enjoy a status in Germany, but not in Italy. How can you control only the third country nationals at the Brenner or somewhere and not the EU citizens? So therefore, that was the logic behind that, setting up common standards for the third country nationals and providing for a right to also move within the EU for certain periods. But there is an inherent dilemma indeed. And indeed, I mean, member states have a tendency when it comes to foreigners to have this feeling, you call it symbolism, political symbolism, to, yes, we can control the borders, or as the Germans say, we want an Obergrenze, all these sort of rhetorics. It is, yeah. Welcome.
Okay, so Martin, thank you very much for the question. And I opened the report, what I have written there. Indeed, many member states extended the scope of temporary protection to Ukrainians who either were already there and at the time of, like, on 24th of February, or those whose resident permits were about to expire. So, and from my list, from my analysis, so Finland, Austria, Germany, Netherlands, Estonia, Lithuania, and Poland granted Ukrainian nationals whose resident permits were about to expire and who were already in the member states temporary protection. Whereas Romania, Germany, Spain, and Sweden granted Ukrainian nationals who have fled before 20th of February and then were already in the EU, but then after came to this certain member state. So we have this nearly, I would say, 10 member states who extended to scope to Ukrainian nationals who have left before, or who already were living there, but their permits were about to expire. So I think this is the project.
They were not regular.
Well, it says, well, like the reports, the Fundamental Rights Agency report said that whose resident permits were about to expire. So I would say irregularly. I think they definitely can apply, but it depends on how member states interpret the Council's decision. About, yeah.
So we have other questions in the room? So I've got a question I wanted to ask Fabian. I think Melton's got a question for Fabian as well. So I wanted to ask you, because you said you've been working for 22 years in the Commission, and quite a lot has happened in those 22 years, obviously just after the Tampere conclusions, and we've seen significant institutional development since then. But we've also seen significant kind of external factors which have had significant effects on the European Union as well. I was wondering, just for you, reflecting as a senior official about the kind of drivers of change and institutional development and the role that, say, crisis has played in that. So have crises of various kinds, from your experience, been a key driver of kind of policy and institutional change, or do you see kind of more a kind of day-to-day grind of slow development of policy, more of an incremental approaches. You know, from that experience, what do you think has been driving some of these developments that you've described to us? I think Melton wanted to ask something as well.
Yeah. So my question, Fabian, I know that you're not responsible for all the Commission's acts and policies, but you mentioned that there's this Darwinism about how people had to hire like migrant smugglers to come to EU, right? And this reinforces that this policy that only the fittest and the one who had the most money can travel to EU irregularly, and this should be stopped. My question is, doesn't the European policies enforce this Darwinist practice? And my reasoning is this. So I'm a Turkish national and I need to apply for a Schengen visa to come to the EU. When I apply, I show that I am employed in Turkey. I have this kind of salary. I have a house, whatever the deeds. And when I was applying as a student, I had to show, as you know, like my parents own this house or car, and I submit pages and pages and pages of documents. I pay around like 300 euros the last time, because now I don't need one, but so you pay all this money, you submit all these documents, and I was a student, and now I'm a public official anyway, so I am employed permanently in Turkey. So even if I have, as a third country national, that's so much difficulty trying to legally come to EU, these people who does not have any consulates, who does not have much money, who does not have any documents and they had to flee, they will not get Schengen visa, so they will not be able to come to the EU. And you mentioned about complementary pathways, talent partnerships, blue card. Blue card directive only applies to those highly skilled labor migrants. Resettlement numbers are so low in many member states. Some member states even do not have resettlement programs. They pick and choose who they want to pick and choose. They normally pick and choose healthy, very high skilled people with a lot of languages. Sometimes they try to pick very vulnerable refugees so that they showcase that we resettled so many people. So none of the member states, as far as I know, that really gives humanitarian visas to thousands of people. So this is fortress of Europe, and what you called about people need human smugglers to come to the EU is the only way they got. And doesn't the EU policies enforce this chain of events and desperateness of people, hundreds of deaths at the sea? Cannot we find, or cannot the EU find a way that can both perhaps protect the interest, but at the same time make sure that there are some valid legal ways for not just for the highly talented persons who speaks 5 languages, have a very good job, but those who actually need protection?
Well, maybe on the first question, which is an easier one, the crisis, definitely yes. I mean, we made jokes to that extent that Osama bin Laden was the best friend of our colleagues in the criminal law unit, because he made it possible to have the political breakthrough for the European arrest warrant. So it was really this crisis in 2001 that made it possible. There was the proposal for this European arrest warrant was completely blocked in council, but then with the crisis, a lot of things became possible. The same in subsequent migration crisis, notably then also in 2015, whenever there is a crisis, there is a higher likelihood that the blocking in council is overcome. So that the member states realize, yes, now finally we have to jump over our shadow. In practical terms, it may also mean that certain proposals are blocked by ministries of interior. But now, if a crisis comes, then suddenly the federal chancellor is intervening, and the chancellor is phoning up the minister of interior. Don't be so stupid. You have to see the global perspective. Agree on it. So it's really, crisis can help, but they can also block. But based on my experiences, indeed, I mean, it's on the one hand this crisis which brings the things forward, and then what is really very, very important that I know is also the relation between council and parliament. If we have both institutions have sort of a pragmatic spokesperson. I mean, you also always have groups, also in the council when you negotiate with member states, there is also sort of a mainstream thinking, either fundamentalist or pragmatic people. And if there are the pragmatic people in both institutions have to say, then it's easy to find, well, it is possible to find a compromise and find good solutions. But you have fundamentalists on both sides, and they're really blocking each other. And I'm afraid that's a bit happening that's just my very personal perception, that was happening in the last year with the current parliament and also with council. Council after the migration crisis very much on more repressive side, parliament more on the more protective side, and on both sides, so not really speaking to each other properly, and this preventing compromise from happening. For instance, I was personally in charge of the return directive negotiations. I drafted the proposal for the return directive, and the negotiations were very carried out in my presence. And then we also had a trilogue with the parliament. At that time, the parliament was more consisting, in my view, with out of pragmatic persons also, who saw the need also for partly repressive policies and not only protective elements. So in my view, pragmatism is always good. If the pragmatic politicians prevail, then there is a chance of having things adopted. On your second point, I mean, Malcolm, you described, I think, very correctly what's happening. I mean, this is the situation as we see. It's not only the border control, it's also the system of carriers liability, for instance, which if you want to come from Africa to the EU, already you're not allowed boarding, because the Lufthansa knows that if they let you board without a proper visa, they will be penalized. So it's also in the forefront. You also is a system, for instance. As I said, I mean, from the EU Commission side, we cannot change the world, and we cannot change the limited willingness of member states of taking in migrants, because this is a fact. I mean, we can say it's bad, yeah, please be more generous, take more up, we can bring forward arguments, but we cannot really change them. So what we try to persuade them, at least in terms of resettlement, be more generous. In terms of legal migration, also open up and try to convince them about the added value of also opening up not only for the high skilled, but for the medium skilled as well. So we try to convince, but I can assure you it's a very hard job. And I'm not saying that member states per se are bad. It's not nasty guys sitting in the ministries of interior. I'm working with them since 20 years. But they have to do a job. And the governments expect from ministries of interior also to implement policies which are then felt by the populations to reflect their will, and the governments want to be re-elected. So it's a very serious challenge, and behind it is, of course, also there are some limits of opening the door, if you want it like that. And you have to differentiate between institutions. Our role as Commission, we try to convince and bring forward good arguments, but also our powers are limited.
Yeah, Hans-Peter. I feel a lot for your answer, because we have survey data, and for example, the externalization to Libya and to Turkey or the external border control are highly popular. In all members, we have done surveys in 16 member states, and large majorities are in favor of this. But I wanted to ask you a question, and for you also a question. That at the very end, you said we have to live with the existing rules, which are interpreted by the ECJ. So is there a possibility that the European Court of Justice becomes a sort of surrogate legislator? And if that's the case, do not the politicians see what's going on, and that they are disempowered by the judges, and maybe that is a pressure on them that they get their act together? It's a question. And for Metem, I thought, I mean, these are very few people. And some countries have even solved the problem, as I learned from you, by extending the temporary protection directive. So it's even less people. And some people end up in limbo because you cannot regulate everything, and you don't think of everything when you regulate. So I think that's a large, not such a big problem. I mean, there are thousands of people involved, okay, but compared to the millions of Ukrainians. But there is another group, and I want to ask you about that group, the Russians. We learned that hundreds of thousands of Russians have fled from Russia when there was this mobilization. So what happens to them? Are there rules for Russians?
Is that correct? Yes, the European Court of Justice is becoming a surrogate legislator. It's already happening now. We see it in a number of judgments. The consequences, in my view, are twofold. On the one hand, indeed, Council or member states then realize, yes, these rules which exist are interpreted in a way which we don't like, so we'd like to change them. This is one consequence. Then the second step is, are we able to change it with the current European Parliament? The current answer is rather no, at least in the assessment of a number of member states. But there is also another consequence, which I feel increasingly, that member states are simply afraid of agreeing on any European rule, because they know whatever is agreed upon will then be interpreted by the European Court of Justice in a rather fundamental rights-friendly way, which goes against some wishes behind in some member states. So, and then this leads, in certain cases, to legislation simply not being even discussed or adopted. So these are the two consequences we are facing now.
Thank you very much for the question. Well, actually, as you mentioned, the question, this is a minor group, but at the same time very vulnerable due to the complexities I mentioned. But the way forward, and this is our basic recommendation, that if temporary protection is extended to all asylum seekers leaving Ukraine, this could have been solved. Actually, the Commission proposed to include all asylum seekers, and the Council said no. We will only give it to refugees and complementary protection status holders. So, as you mentioned, this is not much people to actually, the EU should care about saying that this is not a mess wave or something. So this has a very simple solution: extended temporary protection to all asylum seekers and refugees fleeing Ukraine. But the EU didn't do it, and member states have very fragmented laws about who they apply to, and it's very hard to navigate. This is a labyrinth, as I mentioned. So the Russians. The study includes percentages of Russians. So the Russians who are officially registered with the Ukrainian SMS are actually included in the study. Belarusians as well. So there are like groups from Russia and Soviet republics who were already registered as asylum seekers and refugees in Russia, Ukraine. But Russians who were just tolerated to stay or didn't really have any formal status, then if they come to EU and they cannot return because of the regime's views and they cannot really return to Russia, they need to apply for asylum. But at the same time, member states have this, it's a delicate situation, and we know with what happened with the Russians who left after the obligatory military duty, that some member states are very reluctant to open their borders or grant protection to Russians who have fled Russia, although they might have opposition views. So this is perhaps not very straightforward for some member states.
Thanks. Do we have any further questions? I'm not seeing any, so I think we'll conclude at this point. I think we've had quite a lot of information about what's going on in the EU, so really grateful to Fabian and Melton for their excellent presentations. For the people who've joined us today, thanks a lot for coming along, and the people online. So yeah, once again, thanks to the speakers, and we'll keep in touch with more MPC seminars.